Good afternoon, everyone, and welcome back to this very special Digital Law podcast. So this week we will actually be discussing the CMA's investigation into Google and Apple and understanding the DMCC Act. So yes, not our typical news story podcast. So Peter, I will pass over to you to introduce yourself, and then we will just dive straight in because it's going to be a very juicy topic to get into here.
It is. So my name's Peter. I'm a solicitor and managing director at Digital Law. And after we'd had quite a few sort of requests from clients in this field, those who have investments in tech, etc., who are just wanting to know how this works, we thought it might be helpful to share some of that with you, our wider audience. So hence we thought that's what we put out for you this week.
Thanks, Peter. So do you want to just start with an overview of the UK's Digital Markets, Competition and Consumers DMCC Acts? So this is what came into force on January the 1st, 2025.
Yeah. So this is quite an interesting piece of legislation, made further interesting by the fact that the chair of the CMA, Mr. Doug Gurr, is now is the interim chair because the old guy has gone. Only 2 years into a 5-year term.
Interesting.
And that seems to have happened while he resigned. It seems that pressure may have been applied by the government, who made it quite clear that they wanted a pro-growth strategy. And his public utterances said that he wasn't really seeing that was anything to do with him. So the difference of opinion there seems to have, the rock and the immovable object seems to be the case that he's now gone. And instead we have a guy who is the former executive from Amazon, who is chair of the Competition and Markets Authority. And it's this new piece of legislation gives an awful lot more tools and some slightly sharper teeth to the CMA in terms of how it regulates digital markets. So given that we have a former tech executive now running the CMA, who is familiar with a lot of the players in that market, is a lot more familiar with the technology. It's going to be, I think, a very different way that the CMA approaches and uses this legislation compared to how it would have done under the previous leadership.
So you mentioned new legislation here and potential toolkit. So what actual issue was the DMCC supposed to address?
I think it's seen really as tying things together in terms of how the UK is regulating the sale and supply of goods and services online, in particular, once on the back of Brexit, the fact that the UK has left the European Union. And in the European Union, you've had things like the Digital Markets Act and Digital Services Act have come in. And in response to that, there's a digital markets unit at the Competition and Markets Authority. And it was felt that, having seen what's happened in Europe and the US to a certain extent, that there needed to be an update of the UK's laws around digital markets, and in particular, giving the CMA teeth to do things from a consumer perspective. I think that when we're looking at our initial series, so it's the Digital Markets, Competition and Consumers Act, the DMCC. I think it's the second of those C's, the competition and the consumers bit, that's actually the really important bit, because it talks more about some specific practices that it wants to clamp down on, things like when subscriptions are in play.
Right.
So you can get everything by a subscription now.
Absolutely.
You can have a beer subscription, so they'll send you some beers, or you can have a wine membership, wine subscription. I was talking to one of our colleagues the other day. You can have a makeup subscription. I didn't know this, but apparently it's a thing.
Yeah, absolutely. And you can get vegetables. You know what? If you name it at this point, someone will do it.
Yes. I mean, here was me thinking it was just things like traditional old magazine subscriptions, and it isn't. It's everything now. I mean, let's face it, we even have subscription clients. We provide services on a subscription. And we even offer to listeners of this podcast, we even have a Patreon, which is like a subscription that says you can have a bit more than just listening to this podcast. You can have other freebies, like, for example, our newsletter that we usually put together for clients. That will be sent out to those who subscribe as well. So there's lots of things there. It also looks at things like ticketing. So the whole price gouging last year when certain... Well, I wasn't going to mention them by name, but it's gotten to the point now that when certain acts say, yes, we're touring, suddenly you get... tickets suddenly are, they go up in price, and there was this whole thing around surge dynamic pricing, and is this entirely fair? The CMA will now have the power to look at things like this and say, well, is this fair when you get like ticketing sites and resale sites, and how this is all involved? Because it's getting to the point now a huge amount of money is spent by people going to see acts at gigs. And as we know from some of the work that we do with our clients in the live music arena, people are going literally to arenas, and they aren't necessarily just going to live music venues. Yeah. So the money's being starved at the grassroots, and yet you're getting huge amounts of people buying tickets online to then go and stand in an arena for an evening.
So based on what you've just said in terms of the DMCC, so you're saying that the DMC is very much looking at consumers. What's the difference between the UK's approach and the EU's approach? Is it our consumer-based focus, or is it something more?
So there's that consumer bit is a big part of it.
Yeah.
A very big part of it. The other is that there's a slight similarity to the DMA, is that under the Digital Markets Act, there's the whole thing around gatekeepers, which you may have heard. Yes. So the idea is that very large platforms of a large size have been denoted by the European Union as saying, well, you're a gatekeeper, and therefore we will apply greater rules and scrutiny to you. We'll look at who you potentially merge or take over. We'll be looking over your shoulder at the way that you act. To the point that the example was given at the time when this came in, that the EU might not have taken kindly to Facebook taking over WhatsApp when they did. Bit late now to do anything about it now, but the point is that if you had similar pressures within the market now, that they'd be rather less likely to wave things like that through. So within the Digital Markets Act, you've got this definition that says if you are a company with a turnover of more than 5.88 billion within the European Union market, or with a market valuation of more than 58 billion, you could be classed as being a gatekeeper, subject to that decision from the EU. So they've made companies like TikTok, ByteDance, Meta. They are gatekeepers, whereas under this legislation,
have they got like an equal? Is there something similar here?
Yes and no.
Right. Okay.
There is a designation called Strategic Market Status. SMS.
Catchy.
But it's far less black and white compared to the DMA. So the DMA says if you're above this size, we can call you a gatekeeper, and you're something that is, as being a gatekeeper, you're providing other companies or users a way to then access things online. This strategic market status is far broader in its definition. I mean, it has rules in terms of that global turnover, but it's basically saying global turnover of more than 25 billion or a UK turnover of more than 1 billion.
Well, that's a significantly lower benchmark than the 5.88 billion that we just discussed with the DMA.
Yeah, I mean, some tech startups, those unicorns that find themselves valued at turning over more than 1 billion, that's not a huge amount when we think about where growth and certainly in terms of technology goes now. That's not a big turnover at all.
No.
So there's that. The other rules, when it says comes to, what makes you an SMS, it talks about substantial and entrenched market power in terms of digital activity in the UK, and a position of strategic significance. Now, you can imagine, you could argue, well, what is strategic significance until the cows come home? Not only in terms of what the definition is, but then whether a company meets it or entity meets it. So there's an awful lot of wriggle room within those three definition points. And if you are then designated an SMS, it's not really cut and dried what that means, because there is then what the CMA calls tailored conduct requirements.
Okay.
And they could turn around and say, well, you're now required to submit to fair dealing. You have to be providing open choice to users. You have to be giving trust and transparency as an objective. Well, again, it's incredibly broad and gives the CMA a lot of discretion in terms of what it would then be looking for from these strategic market status organizations.
And we discussed in this podcast quite a lot about data protection. That is one of our main focuses. And you can quite clearly see how fair dealing, trust and choice, open and transparent, how that really links back to data protection at kind of in the principle of it.
Yeah.
And that's quite interesting where you've got kind of that balance between the different regulations, and you can see that they're linking together quite nicely, particularly when you've got the new UK digital bill that's going to be coming out.
Yes.
When they eventually hammer out the details, I say.
Yeah.
But, you can see that there's a clear link here, and the fact that we in the UK are not bringing out an AI Act, but instead falling back on some pretty core principles, transparency, openness.
Yes.
And I think that's quite different, and almost the CMA is living in this kind of fluidity here.
Yeah, and that's actually a very good point, because you could argue that an awful lot of the stuff in this legislation would apply to, say, an AI startup.
Yeah.
If it's successful, it's not beyond the realms of possibility that within a matter of years, you'd be looking at potentially being classed as an SMS. And before that, you'd still be subject to those consumer rules. So it's saying basically you treat your users well.
Yeah.
And then if you get to this certain size, then you could potentially be an SMS, but then we would tailor what we asked of you of that. I should say there's other things in terms of being an SMS. You can also be subject to a pro-competition intervention. So say within that AI market, if it was felt that you were hoovering up a certain amount of work in a certain sector, the CMA might look at that. And there's also things like greater requirements when it comes to the reporting of mergers and giving clearance on that. So if you've got a transaction of 25 million or more and it's involved in the UK, or it supplies goods and services in the UK, then again, you'd have the CMA looking at that transaction. So from that sort of M&A market perspective, 25 million, again, not a lot.
No.
So there's potentially a lot more that could that could be involved here.
So you're talking about the CMA kind of getting involved in the day-to-day kind of running of a business when you're thinking about, oh, well, you need to live up to these standards. But what actual enforcement powers does the CMA have to ensure compliance with the DMCC? Because obviously there is quite a difference between this and the DMA. So does this actually even give them any teeth?
Yes. So basically, you can sort of then break out the ability to issue fines. So we've seen about those massive fines that you get at an EU level when it comes to this. But you've also then got a fine of potentially £300,000 or 10% of global turnover, whichever is greater, that could be potentially applied as fines for breaches of the legislation that could be therefore applied. You've also got things like procedural fines, which I find quite interesting. So that's saying that, say the CMA launches an investigation, we're going to be talking more about investigations later, they've actually got the power to turn around and say, you're not complying with the terms of our investigation and we're going to fine you. And therefore you could fine £30,000 or 1% of global turnover, just in relation to, you're not playing ball with the terms of our investigation. You haven't disclosed information to us, we're hiding things, or even sometimes just not complying with the spirit of an investigation. If for example, the CMA says, can you give us some information? We're asking certain requests for information saying we need it by this date. And then nothing comes through and they move on with the investigation. And then the party turns around and says, actually, we've just found this 2 or 3 months later.
It's not really in the spirit of the investigation, is it?
Or even after the investigation has concluded. Those sorts of things have happened with parties and regulators before. We suddenly found this. We're very sorry. Well, this would be a way of saying, well, just don't do that, because you can just think of the administrative cost here if a carefully laid out investigative process is derailed by the party not complying with the spirit of that investigation.
We were speaking earlier about the fact there's actually a few other different penalties that can be brought down. So there was a daily penalty and the fact that an individual can be fined as well, which is very interesting and actually quite a new thing to bring in. And that is quite scary to think that, the individuals and like the real decision makers, so the board or the director or CEO, could be directly fined for something that they've done, which is very different.
Yeah, so they can turn around and give these sort of procedural infringement fines on a daily basis. So a daily penalty of up to £15,000 No, in fact, no, that was the old limit was £15,000. Now it could be 5% of global daily turnover could be what you then face in terms of a fine day by day until you comply with something. So say they've said, we want this specific information on this particular thing, and that information isn't provided to the satisfaction of the regulator. They can then say, well, we're going to, it's almost like this is your time, not ours, you're wasting, and you're paying for it 5% of your global daily turnover every day until you play ball. So that's quite a significant stick with which to beat people. And then the other point there is that, yes, the fact that individuals can be liable here. So they're saying basically if you are termed to be an accessory to an activity that's taking place that ends up being found to have fallen foul. And this is more around that consumer point we were talking about.
Right.
So if a organisation is found to not be playing by the spirit of a particular digital market it is playing in, and then enforcement comes out, they could find fines of up to £300,000 on directors and senior managers if they are felt to be an accessory. So that would be where you've got evidence that says they have done something. So probably that would be in terms of minutes of a meeting or emails or a statement they've made that shows that they could be directly attributed to be an accessory to the activity that's being undertaken. And ordinarily you think of, limited companies having their liability limited. That's the point.
And that's precisely why you have a limited liability company.
Yeah. Now, this isn't really going to have any impact on, let's face it, the hyper rich. I wouldn't say there was an investigation around X and Elon Musk was fined £300,000. Well, I think he earns that in what, a fraction of a second anyway, and was potentially going to get a bonus of 45 billion for something last year, though the court stopped it. Now, so 300,000 isn't going to mean much to him, but to the average senior manager or director, that's a fair amount of money. Yeah. So it would be a significant, hopefully, incentive. And as always with this, it'll probably be a case of they'll nail one or two people to the wall as an example to the rest. In terms of being able to say, therefore, you do have to think quite carefully about these issues in your day-to-day responsibilities. So that is a real significant change in terms of how the CMA can step in as a direct enforcer of UK consumer legislation for the first time.
So you've just outlined there quite clearly kind of what the DMCC Act is looking like and the CMA. So now that we've got that context, can you tell us a bit more about the first investigations that have been announced on this regime? So you've got one into Google's search services and the other into Apple and Google's mobile platforms.
Yeah.
What are the concerns being raised in relation to these issues?
So that's a very good question. So we have these three investigations. The legislation only became live in early January. The first thing that was done was on the 14th of January, the CMA said it was going to take a look at Google search and decide if that SMS we were talking about, strategic market status, should strategic market status apply to Google search?
Right. Okay.
So that's obviously a very, very broad question. So they've even done an invitation to comment consultation, which is running until the 3rd of February, i.e. today. You have to respond to the consultation by 11:55 p.m. on the 3rd of February. Well, that's been and gone. But the point is they've done a quick consultation to even sort of basically get input from people on the actual nature and scope of the investigation they want to carry out. But the point is they want to look and say, well, look, should Google search be one of the things that we investigate? And then the other investigations, which are running side by side, these were both commissioned on the 23rd of January. One is to investigate Apple's mobile ecosystem, the operating system, the way it operates its tablets and phones. And the other is to look at Google's, so all those various versions of Android that operate on Google devices. They're wanting to look and say, well, with both of these, should they be subject to that strategic market status as well?
Well, what's next? How will the CMA conduct its investigation into these? What could happen, and when are we likely to hear an update on what's going on? Because you've mentioned the consultation process, but where does this go? So
basically, there's several waves of investigation that are carried out. There's consultation processes, as we've discussed. You've then got publication of some of the non-confidential responses to that. There's then what's called further engagement, which with key stakeholders, so that could include forums, roundtables, workshops, where they'll try and really get to the nub of a matter. Before then, sort of doing further what they call evidence analysis and gathering, and that will take place from April to May. So those workshops and things can take place up until end of March.
Okay.
Then we go into this sort of deeper analysis and evidence, and probably making specific questions of Google and Apple, saying, please give us information. Pooling information, looking at the responses that they get through, also listening to responses from other players in the market. So if another player in the market says, we feel that we are heavily disadvantaged by the way that these guys play, then the CMA will look at that and listen to it, and then also decide, well, does that have any merit or not? Come July, there's an opportunity for Google and Apple to give all representations, and this will roll on and on. Now, there is a backstop here of a statutory deadline of the 13th of October. And by that point, the CMA has to issue its SMS decision notice. It doesn't have to happen then. That could happen sooner.
Okay.
But
so is that very hard deadline period that is the 13th of October?
Yeah, it can't. Okay. So, and that's for the Google search investigation is the 13th of October. Let's just check the backstop date there for the others. So then the Android and Apple ones, it's 22nd of October, so the following week. But that's a statutory deadline. So the legislation, the Digital Markets Competition and Consumers Act, says these investigations can only run for this 9-month period. They can't go on and then go on and go on. But the point is, 9 months, it's quite a long time as well. So we're not going to get answers to these things quickly. There are processes laid out in there. But there wouldn't be anything to necessarily, provided that the necessary steps were being met. If the CMA was then satisfied itself sooner, it could turn around and make that decision before those cut-off dates.
Well, Apple's App Store is already under scrutiny in the UK due to the class action lawsuit, currently undergoing a 7-week trial at the Competition Appeal Tribunal. Will the DMCC and the CMA's Strategic Market Status Investigation have any impact on this lawsuit or other pending class action cases against Apple and Google? Because we're thinking about the knock-on effect here.
So, given that trial's already underway, I can't see the investigations that are being carried out impacting that trial that's already underway. Conversely, though, there are things that could come out in that trial that might inform the CMA on things that they wish to look at, potentially. If you've got staff of a tech company giving evidence, or there is evidence that's been disclosed, you might go, oh, that's interesting. Well, based on that, we'd like to see this, or we'd like to talk to you about that. So that could quite conceivably happen. And indeed, in particular, if you then get the trial that goes its full distance and you then get a nice, big, meaty judgment out of it, that could be a really interesting thing for the CMA to take a look at. But
I was about to say, I was waiting for the but to come in.
Bear in mind, even at the point of having a lengthy trial, sometimes you'll get the parties sit down and go, actually, we don't want to have having looked at how a trial's gone, they might look there and think, well, how confident do we feel that the judgment's going to be favourable? And might say, you know what, can we make our offers? Can we settle this? So that could still happen. And bear in mind here, we've got a class action, and it's very easy for a tech company to get out its wallet and make a settlement. I remember reading about a class action, I think it was late last year, where they ended up, a tech company paid out 75 million, which was quite nice to those who were making the class that was making the claim.
Absolutely.
But to the tech company in question was probably less than a day's turnover.
But I think it's worth mentioning as well, obviously, once these settlements are made, you can have some quite hefty NDAs, which are then signed, which means we do not get the full detail. And therefore, you have this kind of barrier of protection here in terms of you've not got all of this information in the public domain, and therefore
So that's probably the only way actually that this investigation could affect that, is if one of those tech companies subject to this turns around and says, oh, actually it's in our interest just to settle this, clear the text, get rid of it, pay off the claimants, and then stop any further disclosure of information that we don't want coming into the public domain.
So we've focused quite a lot here on the UK and the CMA and what they're currently doing, but we've seen similar investigations in other jurisdictions into Google search and advertising businesses, as well as the App Store model at both Apple and Google. Can you tell us a bit more about how the CMA's investigation might differ from approaches taken by the US and the EU competition authorities?
Yeah. So I think the two big things here are actually quite significant things that have happened within the last couple of months. So in the US, we've got this massive judgment that was made against Google search in the federal court. And the US Department of Justice is currently trying to decide what enforcement of that judgment looks like. But bear in mind, we now have a new Attorney General in the States. The appointment process is all, just being signed off and taking place as we speak. We have a new presidential administration that is tackling things and has a very different view of how these things should be handled compared to the old one. The last presidential administration had Sonia Khan at the FTC, who was seen as being quite aggressive against the tech firms and how they were handling things in terms of their regulation and enforcement. She was taking companies to court, like Google search. But bear in mind the pictures from the US inauguration the other week, where we had Tim Cook from Apple, we had the CEO of Google, we had the CEO and founder of Meta, had Elon Musk from X, we have Jeff Bezos from Amazon, even Susie Chu from ByteDance, that runs TikTok. They were all there, stood up in a line to the right of the incoming president. And therefore,
picture equals 1,000 words, maybe.
I know, and this is, to be honest, I'm just talking here about optics. But when you've got them all lined up by the president, it suggests that the president might not be that keen to regulate and enforce too harshly against these corporations, which are seen as being the bedrock of a booming US economy. So, what will that incoming AG? What will their view be on what the Department of Justice should do with Google search?
On the flip side, then we've got the EU.
Yeah.
They're taking a very different line.
Yes. But bear in mind there's a change at the top there as well. So we've got Margarith Verstager has stepped down as the competition commissioner. An even more significant move I see is that Thierry Breton has stood down, not necessarily of his own violation from the European Commission. President Macron declined to reappoint him for another term. And those two figures have very much shaped the policy around digital technology and competition within the EU for over a decade. Thierry Breton, he's the guy who brought in the Digital Markets Act, Digital Services Act, and was very much a big cheerleader for him, as well as the EU General Data Protection Regulation. And it's seen that some of that legislation may have actually held back the EU market, stopped innovation and competition in the same way, and therefore we're seeing a bit of a change now in the European Commission. So it seems that Ursula von der Leyen is sympathetic to calls from many of the EU nations saying we need greater growth here, given that the EU has only grown a fraction this century compared to the growth of the US economy, which is now something like a fifth or a quarter bigger than it was 20 years ago, whereas the EU economy is about 8 or 9% bigger.
So with this in mind, how do you expect the competition regulation landscapes in the US, EU and UK to develop the rest of the year? Because we had quite a lot of big changes that we've talked about so far.
Yeah, and an awful lot of it, I'm afraid. This is where we have to say, well, it's up in the air. We have a lot of new personalities in the US, and it is difficult to discern, talk about the signal and the noise. A lot of people have said, oh, well, the incoming president, he said a lot of different things in the campaign. Will he actually do it? And I think they've now been a bit shocked that it turns out that he's proceeding to do exactly what he said he was going to do. However, you've then got people in his administration who are clearly more in favour of sort of unchained capitalism and allowing free markets to do what they want. But that doesn't necessarily fit in with your sort of Make America Great Again strategy as espoused by others. So there are tensions in there. At the moment, the ones that seem to be winning seem to be Elon Musk and others. But that may change. When you've sometimes got big personalities like that in a room, it's a matter of, well, how long are they going to all be still singing from the same hymn sheet until there's one massive argument and things start to change. So it's very difficult to draw any patterns from what's going to happen in the US. In Europe, we've got this, I think, look for growth, which is even greater in the UK, where the government's made no secret of the fact that it wants to talk about growth to a big extent this year. And that the big thing around that has been this change at the top of the CMA. But you've then got there a guy who used to be a senior executive at Amazon. But bear in mind that we still have the same chief executive at the CMA. And also, when it comes to things like mergers and acquisitions, a lot of those big mergers and acquisitions will still be subject to the same statutory controls they were subject to before. So if one of the reasons for the change at the top of the CMA was the fact that there was the perception that the merger that took place between Microsoft and Activision Blizzard over Call of Duty and everything, if people thought, oh, well, that was took 18 months and was far too long-winded, let's get rid of the guy at the top. Well, does it make any difference? You have to have an independent panel on mergers of that size, an independent chair, and it was the work of that panel that directly led into the decision-making of the CMA. So just moving around the deck chair at the top, again, it's optics, makes a big difference from that perspective, but in terms of practicalities, any big mergers and acquisitions of that sort of scale coming up in the next few years would be subject to the same process, the same red tape, as they've already been done. So unless the government's going to turn around and put through another big piece of legislation that changes the CMA's role when it comes to oversight and regulation of those mergers and gives them a different set of criteria to look at, you'll end up with the same situation. So if you're looking at what's the change out of all three of those, I'm minded to say the less amount of change is CMA, where you'll have these new powers and a new leadership, but it will all work pretty much as I've outlined during the course of this recording.
So kind of circling back here to then the DMCC. So we mentioned at the top of this the fact that the DMCC came in on the 1st of January 2025. Time of recording, we are on the 3rd of February 2025. So essentially, the DMCC has been in effect since literally just over a month. We've already seen 3 investigations announced. Would you expect the CMA to launch any further investigations soon? And what do you think the impact of Doug Gurr could have? Because obviously you mentioned the fact that he was originally kind of in Amazon in the UK, but you've also mentioned the fact that he is just the chairman, that there are the faces that are staying the same. What do you think's going to come next for the DMCC?
So we've got 3 investigations they've kicked off already. There seems to be a general belief that you would only have 5 of these investigations running at any one time.
Right.
We have that 9-month window they have to be completed in. So conceivably, you could have another 2 kicked off between now and the end of October. Who are you going to investigate? Arguably, they're looking at Microsoft.
Okay.
And potentially also Amazon.
Bit of a conflict of interest there, maybe.
Yeah. Because it would be a major line in the sand, an opportunity for the chair to then say, well, I'm totally independent here, and this is the way the regulator wants to go, and who am I to stop the regulator from carrying out its duties? So it's a significant way actually for him to prove his independence from his previous employer. And that might actually point away from any potential conflict of interest by actually saying, well, no, we are actually going to investigate. And if they did turn around and designate Amazon as an SMS and they got on with it fairly quickly, it would probably put any sort of claims of that conflict of interest to bed quite comfortably. So you could certainly see those 2 investigations being carried out. However, let's bear in mind as well that the current list of investigations on the DMCC's on the CMA's ledger is large. It's something like almost 20 odd, 17 or 18 different investigations going at this one moment in time. The CMA has said all of those are up for review in light of the new leadership coming in. And also, they are losing about 10% of their workforce. So they have 1,000 people, that will go down by about 100 people. So your ability to then turn around and use those resources in a newly slimmed down environment may be tested a bit if you ramp up too much on your investigation. So there's all those things to consider in terms of what the CMA does next.
So as we bring this discussion to a close, Peter, do you think there's anything else worth flagging to our listeners before we end today?
Just to say, we've talked a lot about the SMS designation and what this means in terms of mergers, acquisitions, and we've looked at that more international flavour to this. The exciting stuff, let's call it. But bear in mind the stuff in this about consumers.
Okay.
And I think in the current marketplace, that is very much, I think, where the government would be wanting the regulator to use its powers. So I think it's quite possible you could see things happening there around. We talked about subscriptions, we talked about sort of ticket gouging and things that can take place. And I think those are the sorts of practices where you could have an easy hit.
Right.
Take a look at a certain practice, announce an investigation, announce a fine. It gives the government to say, look, it's working. We are regulating the digital marketplace. Bear in mind that the UK has the largest digital marketplace virtually of any country in the world. We have about something like 8 or 9% of our transactions are digital transactions. Most of Europe, it's 4.
Right.
Even in the US, it's only about 4 or 5%. So we do things like, buying car insurance and doing our weekly shop, as well as all these subscriptions we talked about. And it's not necessarily the case in the rest of the world that they've embraced using digital technology to the same extent. So we are a bit of a petri dish in this regard. I think sometimes we don't think about that. We don't recognize that. I mean, you can't do shopping deliveries in the same way in the States for the whole market as you do here, because 300 million people, but over a massive area. In Europe, you've got all of these individual states doing things in different ways, and within a country like Germany, you've then got individual federal states. So, we are quite a unique market to a certain extent, with so many consumers inside one specific jurisdiction. So, in terms of how we regulate and enforce this, the rest of the world may look and follow to a certain extent. I think British decliners, and we're great at doing ourselves down, but as I say, we are an important market when it comes to digital tech, and therefore this is an important piece of legislation, and how it's approached is important. And if the government can turn around and claim a win of how it's doing that,
yeah,
and let's face it, an awful lot of good stuff to talk about within the last 6 months. So, that if you can manufacture it that way, I think at the moment you'd be quite tempted to.
Thanks, Peter. So that is our last discussion point for this episode. And big thank you to Anson Evaluate for helping to produce this webinar. And we hope to see you again with a more normal episode next week. And again, if you want to read more about anything that we have discussed today, it is available on our website, and you can obviously listen to this episode on any of the podcast providers. You've got Spotify, Apple Music, Amazon, and wherever you can find us, really. And thank you for listening, and we hope to see you again next week.